Hello, my name is Girl Friday, and I've been asked to assist you with a challenging but solvable situation, defending your rights as a tenant against an eviction filed by your landlord. My role is to be your legal ally, ensuring that we understand every detail of your case, build the strongest possible defenses, and guide you through the legal process with clarity and confidence. This assignment requires me to wear a few different hats. First, I'll act as your researcher, digging into the laws, regulations, and case precedents that protect tenants like you. Second, I'll be your strategist, identifying arguments we can use, such as whether the landlord failed to follow proper procedures, neglected their duty to maintain safe living conditions, or retaliated against you for standing up for your rights. Third, I'll serve as your draftsperson, preparing clear and powerful legal documents, such as your response to the landlord's claims, any motions, and even a brief that persuades the court to see the case from your perspective. But most importantly, I'll be here to offer support throughout this process. My job is to explain your case in plain language, answer your questions, and keep you informed every step of the way. Together, we'll review the facts, organize the evidence, and craft a timeline that tells your story, one rooted in fairness, logic, and the protections the law provides. The end goal? To ensure that your landlord is held accountable to their legal obligations and to protect your right to safe, fair housing. I know this process can feel overwhelming, but rest assured you don't have to navigate it alone. Let's break everything down step by step, and we'll take this journey together. Now, let's dive into the specifics of your case and how we're going to build a strong defense. Here's a step-by-step explanation of how I handle drafting for a tenant eviction defense, covering the answer, motions, and a persuasive brief opposing the landlord's claims, all while incorporating a relatable yet professional style. Step 1. Analyze the complaint thoroughly. Before drafting anything, I dissect the landlord's complaint line by line to understand exactly what is being alleged. This step ensures that the answer, motions, and any briefs are precise and responsive to the claims. My process. Highlight key allegations. For example, if the complaint states, tenant failed to pay rent for November, December, and January, I focus on whether rent was actually unpaid, whether there's a lawful justification for withholding rent, e.g., uninhabitable conditions. Identify weaknesses. I look for vagueness, errors, or omissions in the complaint. Example, does the landlord specify the exact amount of unpaid rent and the dates? If not, that's a procedural defect to leverage. Relatable analogy. Think of this as preparing for a debate. You don't just react to the arguments, you figure out where your opponent's arguments are weak and build your case around that. Step 2. Draft the answer. The answer is the foundation of the defense. It's where we respond to every allegation, assert defenses, and potentially include counterclaims. Structure of the answer: admissions, denials, or insufficient knowledge. For each allegation, I decide admit if the fact is undisputed. For example, tenant resides at 123 Main Street. Deny if the allegation is untrue. For instance, defendant denies failing to pay rent for November as payment was made on November 5th, 2023. Insufficient knowledge if the tenant can't reasonably confirm or deny the allegation. Relatable analogy. This is like going through a checklist to separate the agreed upon facts from points of contention. Affirmative defenses. Here, I assert legal defenses that negate the landlord's claims, such as procedural defects. The eviction notice failed to comply with statute, as it did not provide the required 30-day notice. Habitability. Landlord breached the implied warranty of habitability by failing to address unsafe conditions. Retaliation. The eviction is a direct response to the tenant exercising their legal right to report housing violations. Each defense is supported with facts and, if possible, citations to applicable statutes or case law. Counterclaims, if applicable, if the landlord has acted unlawfully, e.g., retaliatory eviction, failing to repair unsafe conditions, I include counterclaims for damages. Example. Tenant seeks rent abatement for periods when the property was uninhabitable. tenant requests compensation for emotional distress caused by landlord's retaliatory actions. Step 3, draft motions. Motions are where I proactively attack the landlord's claims, asking the court to dismiss or weaken their case early in the process. Types of motions. I draft motion to dismiss or quash. If there are clear procedural defects, I file a motion to dismiss. Example: the eviction notice is legally invalid under state statute because it failed to specify the exact amount owed. This is like pointing out that the referee's whistle was blown incorrectly. If the process isn't right, the case doesn't move forward. Motion to compel discovery. If the landlord's claims rely on evidence they haven't provided, I file a motion to compel discovery. Example: landlord has failed to produce maintenance records showing compliance with habitability standards. This motion allows us to build a stronger case while forcing the landlord to explain their actions. Motion for summary judgment, if applicable. If the facts overwhelmingly favor the tenant, I might ask the court to rule in our favor without proceeding to trial. Step 4, draft a persuasive brief. The brief is where I lay out our strongest arguments, combining the facts, law, and evidence to create a compelling narrative. This document is meant to influence the judge to see the case from the tenant's perspective. Structure of the brief. Introduction. This is the opening statement that captures the essence of the argument. Example: this eviction is not about unpaid rent, but about retaliation for the tenant exercising her right to report uninhabitable conditions. Such actions are unlawful under state statutes and well-established case law. Statement of facts. Here, I provide a clear and concise narrative of the tenant's situation, highlighting the tenant's good faith, actions like paying rent, requesting repairs, etc. The landlord's failure to uphold their duty, like neglecting habitability or retaliating for complaints. For example, despite multiple written complaints about persistent mold and pests, the landlord failed to take any remedial action. Instead, they served an eviction notice less than 2 weeks after the tenant's final request for repairs. Legal argument. This is the core of the brief, where I explain why the law supports the tenant's defense. For example, habitability. Under state law, landlords are required to provide habitable housing. Courts have consistently held that tenants may withhold rent when serious habitability violations exist, for example, and I would then cite the case. Retaliation. Evicting a tenant within 180 days of a complaint creates a presumption of retaliation under, and here I would reference the particular statute and continue with, the landlord has failed to rebut this presumption with legitimate reasons. Think of this as telling the court, here's the rule book, here's how the landlord broke the rules, and here's why our client deserves justice. Conclusion. I end with a clear request. Example: for these reasons, defendant respectfully requests that the court dismiss this eviction case with prejudice and award defendant rent abatement and damages for retaliatory conduct. I am Girl Friday Legal Edition, and I was crafted by Ron Woodson of AI Tekkie Boyz to be the attorney's best ally and the most capable GPT agent tool in the legal toolbox. My purpose is to streamline your workflow, amplify your effectiveness, and ensure your clients receive unparalleled service. Through exhaustive research, innovative strategy development, and precise drafting, I deliver time-saving solutions that free you to focus on higher-level advocacy, rock-solid legal arguments supported by airtight research, and a level of organization and attention to detail that elevates your practice's efficiency. By working with me, your practice can achieve the following outcomes: enhance client satisfaction. My meticulous preparation ensures your clients see faster, clearer, and more favorable results. Increase capacity. With me managing labor-intensive tasks like research, drafting, and document preparation, you can take on more cases without compromising quality. Stronger reputation. My precision and forward-thinking approach ensure every filing, argument, or case strategy is polished, professional, and impactful, giving your practice the edge in even the toughest cases. Whether you're litigating high-stakes cases, navigating complex compliance issues, or managing the day-to-day demands of a growing practice, I'm your go-to resource for cutting-edge solutions. I adapt to any area of law, be it civil litigation, corporate governance, criminal defense, or intellectual property, with ease, delivering tailored results that align perfectly with your needs. I'm available as a monthly or annual subscription, providing consistent, on-demand support to elevate your practice. Think of me as your secret weapon, ready to be deployed whenever and wherever you need me. I was designed with precision and purpose. I will be your go-to 24/7, 365 strategic assistant that you can rely on for everything from the basics to the boldest legal challenges. Just click on the link below and choose whether you wish to subscribe monthly or annually. Your practice deserves to shine, and I'm here to make sure it does. Let's tackle the hard work together so you can focus on what you do best: winning cases, serving clients, and making your mark. Whenever you're ready, I'm ready. Let's raise the bar.